Hello viewers, this is your Nisha Frasalla. In our previous part video, we covered the meaning of infringement and its type. Furthermore, we also seen about the doctrine of equivalent. In today's video, we are going to cover the areas like the provisions relating to the infringement of patent, then the reliefs granted under the Patents Act 1970. Without further ado, let's see them one by one in detail. Provisions dealing with the infringement of patent, chapter 18, section 104 to section 115 of the Patents Act 1970 exclusively deal with the infringement of patent. Section 104 talks about the jurisdiction. Here, the district court is an appropriate forum in case of revocation of patent is raised by the defendant. At the time, the district court has to transfer such suit to High Court. Then section 104A deals with the burden of proof. Actually, it can be divided under the two circumstances. One, when the product involves, and the second circumstance is when the process of product involves. Under the product involves, the plaintiff has to prove whether his product is infringed. On the other hand, the process of product involves, at the time the defendant has to prove such burden of proof. Okay, let's see section 105, declaration of non-infringement, which is also known as pre-infringement suit. When a person apprehends a threat of infringement proceeding, that person may file a suit for declaration of non-infringement. Then section 106, that is power to grant relief for groundless threats. It is a bit similar to section 105 because here also just because of threat only, if a person is subject to the unfair or unjustified threats, at the time he can approach the court to restrain such groundless threats. He can also claim for damages. Now we are moving to see section 107, defenses available for the defendant. First of all, the defendant can question the validity of the patent. If it is not, he can prove that he used that product for research or experimental purpose, or otherwise he has to prove that his product is totally different from the plaintiff product. These are the remedies available for the defendant. Then section 108, it refers the reliefs granted under this act. There are lot of remedies for the plaintiff or the who got suffered, such as injunction, damages, account of profit. If the court thinks that such infringed goods is harmful or counterfeit products, at the time the court can even order for seizure, forfeiture, and destruction of such product. Then section 109 and section 110 recognizes the right of the licensee as same as the right of patentee in certain circumstance. Then section 111, it deals with restriction on power of courts to grant damages when the defendant is not aware of the existence of such patent. Furthermore, if he has no malified intention, then section 112 was repealed. Section 113, certificate of validity of specification. After questioning the validity of the patent by the defendant, if such patent is still valid, the court may grant for the certificate of validity. Then section 114, it talks about the relief for infringement of partially valid specification. Even the specification made by the plaintiff is partially valid, still the court can give the remedy for that partial valid specification alone. Then section 115 deals with the scientific advices. If a court needs to get any technical expertise, at the time the court can appoint scientific advisors. Further, the court can determine the remuneration from the parliament money. Then we are moving to see the remedies under this act. There are some remedies given under section 108 itself. Furthermore, some remedies also got emerged from the legal precedents. Let's see them. First of all, injunction. Injunction means to stop infringing further. It can be divided into two types. One is temporary. Under the temporary injunction, the defendant has to stop manufacturing or sells such accused product, that is the infringing product, during the pendency of the suit. Then the second one is permanent injunction. Here the defendant has to stop permanently after the judgment it usually given. Then damages. It is a monetary compensation which is calculated based on the loss suffered by the plaintiff. Then the account of profit. Here the defendant has to surrender all the profits which he illegally got because of the infringed product to the plaintiff. Then Mareva injunction. It is emerged from on the landmark case known Mareva Compania Navira SA versus International Bulgaris. This injunction is also known as freezing of assets order. Under this injunction, the defendant shall not transfer or dissipating any of his assets or profits or properties to anyone until the case ends. Then antepillan order. This order is known as search warrant. This order was emerged in the case of Antepillan KC versus Manufacturer Process Limited. Under this order, the plaintiff enables to enter into defendant's premises and to get inspect the evidence against such infringement. Then John Doe order. This is also known as Ashok order. This order is emerged from the case of Taj Television Limited versus Rajan Mandal and others. This order can file against the unknown defendant. It usually it can file against the online piracy and anonymous defendant, then web operators. Then this we comprehensively covered all the provisions on all the areas under the infringement of patent. I hope this video will be very useful for your exam preparation. If you found this useful, don't forget to share, like and subscribe to our channel. Thank you.